probably want to be able to see the screen as we go through. Everybody hear me? Everybody hear me in the back?
We need the microphone.
Is that better?
Yes.
First of all, thank you all for coming today. I realize it's Saturday morning and you probably all had a lot of other things to do, but since the letter of intent was signed, we wanted to kind of move at least to the first presentation as quickly as we could, because that's what we always promised we would do in the past. I'm Tony Faconis. For anybody who doesn't know, I'm currently your association president. Danielle Kirby, who is just got reelected. Yay. And the reason we're up here and not the other board members is that earlier this year, when things started to get focused about negotiating a new deal with the golf club, we are the only two members of the board before last week's elections, let me put it that way, that did not have any links whatsoever to the golf club. We're not golfers, we're not members, anything like that. So the board set up a special committee and empowered the two of us to do the negotiation so that there'd be no question whether the other board members were influenced because of memberships or ties or that kind of stuff. So that's why we're up here. And what I want to do today, as you all know, we finally have signed a letter of intent. We've been working on this for almost 11 months now. Today we're going to bring everybody into that and let you know where we're at and what happens next and what the details of the deal are, the big details anyway. It is only a letter of intent. We do have to do now arrange contracts and so forth. But the one thing I would say to all of you, the best thing people can do is take the time to learn what this is really about. And it is a complex deal. There are a lot of pieces to it. And I'm sure there are things in here that everybody in this room are going to go, wow, that was really pretty good. And there's also things that the same people are going to go, wow, I didn't like that piece of it. Okay? But I would urge you all and ask you all, please withhold your judgment until you see the whole thing, because we do have to deal with it as a whole. Okay? So ultimately, all of you are going to be asked to balance the goods and the bads in your own opinions when you vote. So I just want to get that out there right now, because I think that there are some interesting things in here. So we'll see how it goes. I'm going to try to move through this presentation. There is a lot of information. Some of it I'll go through fairly quickly. Some of it we'll probably spend more time on. And the ultimate objective is to get through the presentation, and then we'll open it up for questions and answers for whatever questions you have after we've got through the whole thing. So if that's okay with everybody, then we're going to get going. Here's the topics we're going to cover. A little bit of history and background for people who may not be familiar with it. That I'll go through fairly quickly. And we're going to spend most of our time in this bullet, what's in the new agreement, what are the key provisions. We're going to talk about what are the risks of the SOA for this deal, what we're going to do next, and then what I think is really kind of the key bottom line of the whole thing, and what we'd like you to do, and your chance to ask questions. So the thing, I think you've all seen before, this map is the same as that map. The takeaway of all this is this outside line is the boundary of all of Somerset. Okay, this is Sierra Canyon, you got Eagle Chase and places like that. Clubbett Town Center is right over here, I think. No, I can't see the map very well, but in any event, this is all of Somerset. The red spots are all golf course property. That is, a very visual way to see how it runs through the whole community and how much is there. That is the golf course. And the reason that's really important is that when Somerset was developed, the golf course, golf club, I'll use those terms more or less interchangeably probably most of the day today, most of this morning, but it was set up as a totally separate legal entity, okay? The SOA does not own the golf club. The SOA actually has very little to say about the golf club. That property that you saw in red over here, none of that is subject to our CC&Rs or our rules. We don't really have any say about what happens on that property. So it's kind of an odd situation in that you can see the property goes all through the community. Clearly what happens on that property affects all of us, our house values and stuff, but we have no say in what happens on that property, and that's very important to understand. Basically back at the latter part of 2010, the developer turned over the golf club to the equity members at that time. But very importantly, he reserved certain rights. He basically put a reverter clause, which is tied to the deeds to the land, that basically say if it doesn't operate as a golf course for a set period of time, and that time's changed, currently I think it's 12 months, but if it's not operating as a golf course, everything goes back to him, the land and all the water rights with that land. Okay? And that's what we refer to as the reverter. We'll be talking about that a little bit later. And so basically about a year after the golf course was first turned over, then the board of directors, and at that time the board was developer controlled. There were 3 members, 2 of them. One was Blake Smith himself, and one of his employees was the second one, and we had 1 homeowner representative. So that's the developer control board. And they put in place what I'm sure all of you heard lots about, our current amenities access agreement, which has been talked about quite a bit in this community. That access agreement basically was in exchange for payments from the SOA. SOA members, all of us who aren't golf club members, had access to certain amenities. And the key thing was the contract was originally negotiated as a 10-year contract, but it was then broken up so that there was the first 3 years, and then there was an option to renew. There were actually 2 options total, one for 3 years, and then at the end of that, one for 4 more years. Don't jump on me if the 4-year option came first. I don't remember right now, but anyway, there was a 3-year and a 4-year option. So the whole thing would have been 10 years, but there were some options where the SOA and the golf course would say, we don't want to continue this. Okay. This is basically the current agreement that's in place. Basically, everybody in Somerset, every unit in Somerset could get 2 foursome golf rounds per year. What we pay depends on the time of year and the time of play you make your reservation on. Our members were allowed. Okay, and when I say our members, most of the golf course members are our members too, but I'm just using that as a way to distinguish between golf club members and non-golf club members. So, SOA members, our members, were given use of the driving range, but only from the back of the range, and you had to pay either, I think it was $3 or $5 for different size bags and balls if you wanted to use the driving range. Access to golf lessons and clinics at whatever the going rate was for those. Use of the bocce ball courts, that is free. Leagues, I understand, charge a fee to organize and whatever the league, but as individuals, anybody can go up there, play bocce ball. We got access to the restaurant, access to the pro shop, catch and release fishing in the pond is down here, behind this building. But that's basically the agreement, okay? And what did that agreement cost us? Well, basically, the agreement, and you probably can't read this, this is the detail down here. For the first 3 years, it was $15 per unit per month in the units. And after the 3 years, if it was continued, it dropped to $12 per unit. But the number of units would be higher, presumably, because we keep building out. So, rough numbers, to get to the first 3 years, which would be our first chance to stop the contract or to say we don't want to continue with the contract, and that, by the way, is next December, it's the end of 2014, we would spend $1.3 million. If it got extended through the entire 10 years, the cost of the SOA, this is in addition to what each of you would pay for some of those various fees for using these, would be approximately $4.2 million. Obviously, we don't know how fast units are going to build out, but these numbers are based on some of the projections that were in the 2014 budget. Okay? And the key question is, if we went all through that, whether we stopped at the end of the first 3 years or whether we continued for 10 years, at the end of the term, what does the SOA have for the money it's put out? And the answer under the current agreement is nothing. Basically, we have access during the term of the agreement, and after that, they go their way, we go our way, and there's nothing left. Okay? So that's kind of a key point this is an important slide in terms of understanding the agreement that's already in place. Okay, and we are working under that agreement right now. Okay, so then what happened? Okay, basically, January of this year, well actually a year ago, November, we had our first election to elect an all-homeowner board. The developer was turning over control. Our board, of which Danielle's a member, Curtis is a member, Rayleigh and Dave Hughes, who aren't here right now, they were members. We took effect January 1 of this year. Okay, that was the turnover date. Basically, within 2 weeks, we started talking to the golf course about what's going to happen for 2013. Because under the existing contract, they were going to build a putting course. And, and then that would all work the way we said. All those numbers on the previous slide, by the way, are based on the existing contract, the way it was originally written. As some of you may know who attended some of the board meetings, we've actually been able to make some modification in the way we pay, which has reduced the cost. But the numbers I showed you are what was originally signed. Okay, because I think that's the appropriate comparison, because that's what we would have. That's what we have to look at, basically, if we didn't make other changes. So we started talking with them almost immediately to say, can we renegotiate this deal? Actually, the initial discussion started, they actually approached us first, saying, we're about ready to get started on building the putting course. Are you guys sure that's what you want? Because under the original agreement, we did have the option of changing, exactly what got built. That's how the discussion started. They were very short term. It was, the golf course, come spring, we're going to start building. What is it that we actually want? Very quickly, after the first 2 or 3 meetings, it became evident that there may be an opportunity to not just tweak the amenity for 2013, but to really step back and possibly redo the whole agreement for a much longer term benefit to Somerset. And that's how we got to the point where we're at today. That we started talking with them and we capitalized on that opportunity. The negotiations were going along. I think most everybody knows May 31st, that was the date on the letter. We got it, obviously a couple days later, we got a letter from the Office of the Ombudsman. A resident had filed a formal complaint with the state about the golf course deal, the amenity access deal that I just described. They said, well, we think there's enough there that we think we want to look into it more. So basically, that brought things to a screeching halt shortly. There was a meeting, and the reason the Attorney General's office is involved, in case anybody knows, because the Department of Real Estate, who's the actual entity that pursues the complaints, because they're a state agency, anytime there's legal action, they're represented by the Attorney General's office. Just like we have our attorneys, the Attorney General's office is the attorney for the Department of Nevada Real Estate Division, I think is what the NRED stands for. We basically had a big meeting down in Las Vegas with the state people as well as us, the previous, the developer who was the previous board president, and his appointed employee as well as the golf course representative. And in that meeting, that's where the Department of Real Estate found out that we had already started negotiations to try to change that. And so what they did is they basically said, okay, we'll agree to just not move forward with this complaint, you know, suspend the hearing, suspend the investigation to give you guys time to work it out if you can. And if you can, we'll take a look at that. And if, you know, we told them we were planning to put it to a homeowner vote. They said, well, great, if it passes, then that's what the homeowners want to do. All the rest of the complaint goes away. If it doesn't pass, then they have the option whether they would still want to pursue whatever they wanted to pursue their hearing. So that's kind of where things develop. But at the same time that we started talking with the golf course, the new board was in place. Believe me, there's a fairly steep learning curve about what you have to learn about Somerset as a new board member. Some other issues started to emerge, which to us were pretty big risks to Somerset. And people in this room may or may not be aware of this. Okay, the Somerset Owners Association has its own golf course, the little 9-hole executive course, the Canyon 9, right? We have water rights to Water Canyon 9. They come predominantly from the Truckee River. Okay? The association does not own any of the infrastructure to get water from the Truckee River up to here. Okay? So that's a big problem right there. Who owns it? Turns out the golf course owns it. Okay? The way the system, the watering system was designed in order to take advantage of economies, there are parts of the system that are common that both courses use and parts of the system that are individual to each course. But for the common part, which is primarily getting water from the Truckee River up to here, that was, for whatever reason, the developer put ownership of that into the country club, not into the association. So we really don't have any way to get our water up here. Now, the way our Canyon 9 watering system works, we've got the big pond where the fishing is now, where that little dam is right behind here. It's at hole 9, I think, of Canyon 9. Okay, that's where all of the equipment that pulls water to go through all the various sprinklers on Canyon 9 draws its water from. Okay, we don't own that pond. We don't own the pond. We don't own the little dam there. If you see that metal building that's just off on the walking trail going down the canyon, that's where some of the pumps are that get water from the river up to here. Please hold questions until later. But we don't own that pond either. Okay? So you can kind of see an emerging problem right there. If anything happened, whether it's the golf course sold the property to some other golf course operator, or the developer took it back, or they went bankrupt or just stopped operating for whatever reason, we don't even have the right to enter and turn on the pumps to water our own golf course. Okay, that's a problem. The other thing is, as we talked earlier, their property runs all through our community, and it clearly affects our home value, but they're not at all tied to us in any way, CC&Rs or bylaw. There's really no tie there. And the really worrying part is either if the golf course sold the land to, say, a third party, it would have to be some kind of golf course operator because of the reverter, or, you know, even if they did, if it reverted back to the developer, it's very easy to develop the golf course property for more houses. It's very easy to strip off the water rights so the developer can take them somewhere else, some other project. So even if he abandons the land, we can't afford to water it if we had to actually pay a water bill for that. So you can kind of see that at least in our minds, these became real big issues in terms of the long-term future of Somerset. Forget about the golf course and, you know, whatever agreements we have with them. These are really strategic issues that will determine the future of Somerset in terms of, do we even have control over what happens in the middle of our own community. I know a lot of people weren't aware of some of these things, but believe me, they're there. Okay. Yeah, we weren't all aware of some of that when we first became board members. So what's happened since then? Okay. Well, we resumed negotiations after the meeting with the state people. We resumed negotiations. Like I said, this has been going on for 11 months now. We've looked at all kinds of options, believe me, and you know, we're always open to new ideas, but I think we really looked at pretty much every concept either we could come up with or the golf course people could come up with, and that's a big part of the reason why it took so long to go through this. There were many times where either party could have easily just walked away, but fortunately, most of the leadership of the golf course are also SOA homeowners, so they, you know, we saw some of the importance from their side, but they also saw the importance of this deal from our side. And I think that's what kept it together. Well, we finally, as we announced a few days ago, we finally got a letter of intent signed, and I'll point out 3 affected parties. It's us, it's the golf course, and it's the developer, because he still has that reverter right. And he, you know, technically, all the land and water goes back to him. So we had to get him tied into these negotiations as well, because the other 2 parties, us and the golf course, don't really have authority to do everything we wanted to do. Okay? And this is really important, which is why I put it in both. Okay? This deal ultimately has to be approved by both the homeowners, and even though there's a lot of overlap, but it also has to be approved by the equity members of the golf course. So while what we're talking to you about today is what both sides have agreed to, it still has to go to a vote. Okay? But if it does, I mean, it will go to a vote. If it passes, one of the provisions is that the existing agreement that you saw on those earlier slides goes away. And it gets replaced by this. We're not tweaking the agreement. It's really an either or. Which also means if the vote doesn't pass, that other agreement is still in force until something else happens through legal action or whatever to set it aside. Okay, so that right now that we're operating under that agreement, we have made some tweaks to it to improve it for the SOA. If this deal gets approved by the homeowners and the equity members, the other deal just goes away. Okay, and this deal replaces it. It goes away in its entirety. If it doesn't pass, that deal is still the deal we have to deal with. That's too many deals. Okay. So, how did we approach, what we're going to get into now is talk about what's in this new agreement. What have both the country club and the SOA and the developer agreed to at this point. Okay. First, I want to start with just making clear what our guiding principles were in these negotiations. Okay. Once we got into long-term negotiations, we put this on the table first thing. What was that, like back in March or something like that? What we said to the golf people right off the bat, and we stuck to this throughout all the discussions, that if the SOA is going to get into a new and presumably long-term deal, because again, getting into a 1 year or 2 year or 5 year deal that ends and then we have nothing, what's the point of that? Okay, but we said 3 things that, and we just told this, we said this is going to guide our thinking, and this is going to guide how we evaluate things. The first thing is we're looking to do something about those strategic risks that I had on that other side. The fact that we don't own our water pipes to get water here, the fact that we don't own the pond that we need to pull water out of, those strategic risks, and the fact that all this land can revert to the developer and he can do whatever he wants with it, basically. Okay. Second thing is clearly because the country club is a separate legal entity, and because of the restrictions on all homeowners associations in Nevada, okay, we can't, say it's our problem to deal with them, because it's not. We're restricted as to what we can spend money on, what rights we have, how we protect our homeowners. That one of the things we're looking for is part of the deal. We're going to be trying to see what can we do to protect Somerset regardless of what happens to the country club. I know I can't tell you whether golf is going to recover and whether country clubs are real. And I would welcome anybody in this room if they could tell me what the environment for golf's going to be 5 or 10 years from now. Okay? But our responsibility to the association is to try to protect it no matter what. That was a key principle. And the last thing, which came up many times, is we said whatever deal we do, Danielle and I, and we ultimately brought in Ray because of his financial expertise and his previous involvement, because he knew the history of stuff, but he was not an official voting member of our little negotiating committee. But whatever deal we do, we need to be able to stand up in front of all of you and say, we think this is a fair value. So those were the things that guided all of our discussion. So, okay, get ready, hold your judgment until you see all of it. Okay, so what is it that we've got in this new deal? Okay, first point, go ahead. Okay, we're going to be buying real property. If it's approved, we're going to buy real property from the golf course. In essence, we're going to buy almost all the real property. And I say almost, we'll get to that in a moment. Okay, so what are we buying? First of all, we're buying 400 plus acre feet of water. Okay, which means we, the SOA, will own the water rights. So no matter what else happens, we'll be able to keep that area green. Okay, whether it's a golf course or not. We're going to come back to that later. But we're buying that, and we're also getting 100 acre feet of supplemental water rights, which I'm not a water expert for Nevada law, but as I understand, that basically allows us to change where we pull water from if it's not available from a specific permitted source. Okay, so we'll get 400 acre feet of water. It's actually a little bit more than that. And we're going to, by the way, all these numbers that you see on this are all subject to our due diligence review. So this will all be pinned down on whether it's 403 or 412 and a half or whatever. But that's the number we're talking about, plus the supplementary water rights. We will get the facilities to bring the water from the Truckee River up to the Canyon 9 Pond, and we get the ponds. Okay, so that means we still have a co-designed system, but what changes, instead of the golf course owning it and us having to hope nothing happens to the golf course, we will own it and we will provide the service to the golf course for their water rights just the way they provide it to us now, but it will securely be owned by Somerset. Here's the big one. We're buying 220 some acres of, and I put it as green space because it is possible to be used in different ways. Okay, and we'll talk about this a lot more. But we're basically buying the golf course, or I should say, think of it this way, we're buying the land under the golf course. Okay, we are not trying to get into the golf course business. We are buying the land, that includes the the driving range, for example. It includes, well, this includes all the wells. The water permits are a combination of river rights, well rights, and some spring water rights, okay? We're going to come back to this later, but basically, the country club is going to continue to own approximately 6 acres of land, which is up where their current building site is and where the trailers are. The rationale for that we'll get into in just a couple of minutes. Okay, they're going to keep 6 acres. We get everything else. That includes the maintenance building, which is about 7,500 square feet. That was like they paid like $1.5 million to build that building there. Okay, that will become our property. Okay, and here is the main one. This is, in my mind, the most important one. We get the reverter rights. We have agreed with the developer that he will sign all of the reverter rights over to us. And we actually have some flexibility that as we work out the details of the legal contracts, whether he assigns those rights to us or whether those rights just go away, so that the owner of the property, in essence, is the full owner of the property. It can't go to somebody else under any kind of reversion deal. That's up to us, and we haven't gotten to that point with the attorneys of, is there a benefit to go one way versus the other way? But what has been settled is the Somerset Owners Association will own the reverter rights. So that, why is that such a big deal? We've solved two problems here in particular. Because of the water, okay, Somerset will never go through what Northgate or Deandria did. Okay, we will always be able to keep it green, whether it's a golf course or not. Okay. And because we own the land and the reverters go away, the association, which ultimately means the homeowners, will always be in control of what happens on that land. So all the issues about having a developer build more houses, or having the water rights stripped out like they did at Deandria, or somebody coming in and doing something that's not in the best interest of the homeowners of Somerset, that now will be completely in our hands, which right now we've got nothing to say about it, basically. What else is in the agreement? These are the key points. And so before we switch the slide, I'll just ask you, kind of keep these in mind. And I'm sure this is where a lot of the questions and answers later will be. But these are, to us, this is the heart of the agreement. But there's a lot of other stuff in it, too. Okay, so what else is in it? Well, here's a comparison with this part of the slide is essentially, this half is what I showed you earlier about what are the current amenity access agreements. Okay? This side is what happens to those under the new agreement. Well, instead of paying $15 a month per unit for access up until whatever the end of the thing is, we're going to pay nothing more, and access is permanent. As long as the country club exists, we have access to those amenities. We're not going to pay anything more for it. Instead of 2 rounds of golf, you'll get 4 rounds of golf. Okay? Now, there is, and on a lot of this stuff, we're going to post this presentation, we're going to post the letter of intent, it'll be, and we're going to post the video of this discussion, and that'll all be on the website by Monday afternoon. It'll all get posted. They'll be working away on Monday to upload all that stuff. So there's a lot of little details. So read the letter of agreement, but in order to get to the foursomes, one of the things we agreed to is right now, the golf course has a limit on how often its own members can bring the same guest. And the reason for that is, obviously, if you've got a buddy who's a member, or you guys want to kind of split the cost, you can have 4 people, and you just keep bringing the same guest over and over. There's no incentive to join the club. Okay. So, and their, by the way, their restriction right now is they can't bring the same member more than 4 times. Okay. So we're just going to do the same restriction for the same reason, quite frankly. So everybody, there's 4 foursomes per house per year to play, and we will, though, any individual. So if somebody owns 8 lots, they don't get 32 rounds. Okay, that's really what it means. The other thing is these 4, periodically the golf course does promotional deals, whether it's to the public, Groupon or Living, whatever it is. You can tell I don't think or they do promotional offers. Those won't count against your 4 rounds. If you want to do those, you have the same right that everybody else has to do those. But in terms of just saying, hey, I want to walk up and play golf, reserve my tee time, 4 times a year. Okay. Driving range. This was a point of contention. I know I heard from a lot of people this is both one of their favorite amenities and one of the most hated amenities because of this feeling that Somerset members who weren't golf club members had to go to the back, and you had to wait for that shuttle, whenever they did that. Okay, the rules are changing. If you want to go to the back, first of all, they've promised to improve the service, and that will be worked out in the actual contract, exactly how that'll be done. But if you want to go to the back, you can hit as many balls as you want for paying nothing. You can stay out there all day if you want. It's going to be set up exactly the way the front part is set up for equity members, in that there's just going to be lots of bags of balls back there. You don't have to go buy the balls, okay? They'll just be back there. If you want to shoot off the back, you can go spend the whole day there, okay? If you want to shoot off the front, which is the grass area, you can do that too now, which is currently not allowed, okay? You will get unlimited balls the same way equity members get unlimited balls from the front, but you will pay $10 a day. So if you wanted to go out there for 18 hours, presumably you could. And you just keep hitting balls. Bocce ball will still be free. Okay. Access to the restaurant, pro shop, golf lessons, clinics, that kind of stuff doesn't change. It's basically the same as it is under the current agreement. Although there is a kind of a built-in upgrade, hopefully, and that is if the country club does build an actual, a permanent clubhouse, okay, we'll still have access to the restaurant in that clubhouse. It doesn't go away when the temporary building changes, okay? You'll see this other one with the double asterisk on the price. Basically, right now, the price is the same, but as the country club has already done, they have the right to change their price, and so we abide by that, but we actually negotiated some limits on how much they can change it, and it's tied to both non-equity member rates and equity member rates. Read the letter of intent. That's kind of a fine-tuning tweak, but the prices are basically the same as they are right now. Okay. So these are some of the other things that are in there. Okay. Now, here's the biggie, which I'm sure most of you are already asking yourself. What's that question? What do you guys Okay, so I'm going to show you this, and then I'm going to put it in context so you can understand why we settle on the numbers we settle on. That's right. So you look at the big reveal. 2 3/4 million. Okay. Compare that to the 4.2 million that we talked about ending up with nothing under the current contract. Key point. One-time deal, no other money, no other obligations toward the country club. So in essence, what we're doing is we're buying a bunch of land, we're buying water rights, we're getting the reverter right. 2 3/4 million. Now, is that a good deal? Obviously, you guys have to make up your own minds, but we think it's a really good deal, and I'll show you why. Okay. Is it a fair price? Well, here's some kind of benchmarks. Northgate Golf Course sold in 2011 for $2.4 million with no water rights. Okay, which is why it looks like it does today. And I know at one of the discussions we had at the discussion that was at the Aspen Lodge on the CC&R changes, we had as many of you know, several of the homeowners, Somerset homeowners who were on the Northgate Golf Course that came up to their backyard, as part of making a deal with the trust that owned the land and with the city, they bought some additional land. Okay, we had one of those guys at the meeting the other day, and somehow the issue of Northgate came up. I don't remember the context. And I said something like 2.4 million. He jumped up and says, no, that's not right. We paid 2.7 million. 2.4 is what was in the paper, so that's why we used that number. Water rights, what are they worth? Well, now this is a little bit old, 2005, but it's Washoe County auctioned off 174 acre-feet from the Sierra Sage Golf Course. Golf course water rights got auctioned off. In 2005, they were worth more than $40,000 an acre foot. I know that our developer paid for some of the water rights that are here as part of what we're getting from the, he paid over $50,000 for some of them per acre foot. What's the current value? Economics have changed, obviously. Okay. What I've been told is a good typical number, and I got this from the water surveyor that does our water permits and stuff like that. Roughly $6,000 an acre foot is the going rate. Now, obviously, and that is kind of a generalized number because, you know, whether you have river water rights or groundwater water rights or spring water rights, the prices are all a little bit different. But he assured me that if I wanted kind of an average general number, $6,000 is about what the current market is. So right there, at 400 acre feet, we're getting a little bit more than that actually. But we'll confirm all that during the due diligence. Right there, that is $2.4 million. So if you look at just the land and the water, kind of current values should be around $4.8 million. Okay. On top of that, we're getting the security that I talked about. Somerset can control what happens to that land from here on out, regardless of what happens to the golf course. How do you quantify that? I don't know. But, you know, make up your own minds. But to me, that's worth a lot in terms of knowing that our home values are going to be protected forever. Okay, I mean, there may be other things that happen that affect our home thing, but it won't be because the golf course went brown. Okay? And on top of that, we get the little perk of perpetual access to the amenities. I apologize, I think I'm getting a cold or something. But in any event, the bottom line, in our opinion, is when you look at the whole thing, we're getting a pretty good deal. We're getting a lot of stuff that's important to this community, and we're getting it at, I think, a really pretty decent price.
How many homeowners are there?
Right now?
Yes.
2,478 activated units, moving toward at full build-out, 3,600. Things keep changing in terms of how the unbuilt stuff works, but that's what we're projecting.
2,000.
Okay, excuse me, we'll hold questions till the end. Yeah. But the number that is relevant right now, because it is using some of these other calculations, 2,478, the number of units that are paying assessments right now. These are supposed to pay assessments. Okay, next slide. Let's keep putting this in context. Okay? Under the current agreement, we're paying, on average, roughly about $420,000 a year to the golf course for access to the current amenities that ends with nothing left over as soon as the contract ends. Okay. How are we going to pay that? What we propose to do is basically take out a loan. We've talked to banks. We've done some preliminary discussion. Okay. And by the way, it's not a mortgage. It's not a loan. The way banks work with homeowners associations, you don't put up the land or the water rights as collateral. What you do is you basically say, we have assessments, we're going to use the assessments to pay off the loan. And I know the question is going to be, okay, how does that affect our assessments? That's the next slide, but not yet. Okay. But basically, we've talked to several banks on a preliminary basis. Current terms are about 5%. Here's some examples that if we amortize, if we take out a 20-year loan, these are annual loan payments with total about $220,000, which is about $200,000 less than we're already paying. And this number is built into the current assessment. Okay? Even if we did 10-year amortization, $350,000, that's still less than what we're paying now. If the interest rates change, okay, roughly speaking, a 1% increase in the interest rate, because it's going to be a few months, even if everybody loves this deal and wants to vote for it, by the time we do due diligence, arrange the contracts, and get to a homeowner vote, it's going to be a few months. Let's say interest rates go up. If interest rates go up, say 1%, 1 percentage point, how does that affect this? It actually increases our payments by about $20,000 a year, which comes down to 67 cents per unit with our current number of units. Okay, so let's put this in context. Remember, right now, built into everybody's assessment is $15 a month that goes toward the country club. Go ahead, next slide now. Okay? If we were to take out a loan, what would it cost to service that loan? It would cost approximately $7.40 to $11.77 per unit per month. What's the range? The range is just based off of what I showed you at the previous slide. If we amortize for 20 years, you get the lower number. If we amortize for 30 years, you get the higher number.
10.
I'm sorry, 10. I'm sorry, thank you. If you amortize for 10 years, you get the higher number. If interest rates change, if we do 25, we're in between somewhere. But I wanted to give you a range. Okay. Right now, we're paying, each of us are paying $15. It would cost between $7.40 and $11.80, say, to service this loan right now. Okay. Obviously, as Somerset builds out, that number drops. Okay. I just used 3,500 units as a reasonable estimate. Okay. When we get to 3,500 units, it would be, you know, 524 to 833, depending on how long the loan's for. There's also a, well, let me cover the next one, then I'll make this point. Okay, our intent is the money that's left over between whatever we have to pay and the $15 that's already baked in. The first use of that should go to reserves. That gives us an ability to build reserves and build them fairly quickly without having to change assessments. Okay? At some point, reserves will be at a comfortable level, you know, because when you look at the golf course, even if you look at Canyon 9, our reserve study, there's not a lot you have to reserve for. You know, in this deal, the biggest thing we have to reserve for is ultimately going to be the water infrastructure. That's where the equipment and the pipes and stuff, you know, other than that, you're going to have a few, maybe a retaining wall or something like that, but, you know, there is, I guess, some reserve for landscaping, but, you know, our Canyon 9 reserves for the golf course are really pretty low compared to everything else. So we expect we'd be able to build reserves pretty quickly, okay? And then after that, it's up to whoever's the board then and the finance committee and whatever to decide what to do with that money. But there's another thing, I think, by taking a longer-term view rather than try to scrape up the money right now to pay for this, and that is, if we scrape it up right now, basically everybody here is paying for this deal. Okay? Fact is, 5 years from now, 10 years from now, some of us won't be here for whatever reasons. Other people are going to move into the community. If we do it this way, that ensures that the people who move in the future are going to pay part of this cost, instead of having just current residents pay for it and having future residents take advantage of it. So that's another reason why we think this makes sense. The bottom line, oh, let me get to this, because this is really important. Part of this deal is that the golf course will be giving us a full warranty, which means for 4 years, on everything we get, which means anything that breaks, needs to be fixed, whatever, they have to pay for it. So even though we're going to be putting money in reserves, we're not going to be taking any money out of reserves for any golf course property. So that's another reason why this will help us build reserves fairly quickly. Okay? They're going to give us a full 4-year warranty on everything. And we will do our due diligence stuff anyway, but you know, with homeowners inspections and stuff, we've all gone through that. They know the condition of that stuff better than we know it. We didn't want to let them off the hook to say if they knew something that we didn't, that we couldn't find out, that somehow we're going to be hit with a big thing, you know, a big bill. Full 4-year warranty on everything we buy. So the bottom line is, we can do this deal without changing current assessments and with the potential for lowering assessments in the future as the community builds out. Okay. Okay, the next question is probably on somebody's mind out there is why is the golf course keeping 6 acres? Okay, and we went around and around on this, and there's a lot of reasons, but the bottom line is it comes to, it gives them a chance to build a clubhouse, and it keeps us out of it. Okay? Because if you remember, for any of you who were at the presentation back in April when we thought we were like this close to a deal, and then it all unraveled, a lot of the comments we got were, well, wait a minute, if we bought, and at that point they were going to sell us like 5 acres, and I'm embarrassed to go back and repeat what the price was, because it was a lot more than we're paying for this. But, we'd have to share the parking lot. There were issues of, well, if we build a clubhouse, if we want that to expand some Somerset amenities, now we're tied to them because the building's going to be shared use, and what does that really mean, and how you deal with that? And does that mean we're going to have to pay for a bunch of more stuff in the future, or are we going to end up building them a clubhouse? They keep the land. They're responsible. We have nothing to do with it. Totally separate deals. So the association does not get pulled into any ongoing financial obligations with regard to a clubhouse or anything else. Okay? We also, though, did get some good protections, I think, as we were concerned. Obviously, if they own it, they can sell it, that piece of land. First of all, our thinking is, for those of you who've been up there, it's kind of right in the middle of a residential, and you got to drive past these houses, and it's sitting up there, and there's no other way to get in. So if we own, the SOA already owns the common area, and you own the houses, the SOA owns the golf course, which is what butts up to every other boundary of that 6 acres. How many people really are going to buy that? Okay, so we think the market will be fairly limited. But we got 2 things out of this. One is we got a right of first refusal if they do try to sell it. And it has to be a bona fide offer. I mean, it's not like they can say, hey, we're about to sell it for $40 million if you guys want to buy it. They got to show that they actually have a buyer with real money that's about to buy at whatever price. But we didn't want to try to structure this. We wanted, let me put it this way, we wanted to structure it such that it gave them a strong incentive to really try to make a go of it up there. Okay? And so, to that end, if they try to sell it within the first 5 years, our right of first refusal is 50% of their best offer. So if they got an offer to sell it for $1 million, we can buy it for $500,000. Okay? And that the reason for that is specifically we don't want them to decide they can make more money by just flipping the property and going on. I don't think they're going to do that. I don't think they would anyway, from the extent I've got. Their challenge, and what's reflected in this deal, because they were pretty tough negotiators, as we were also, that their challenge is, it's kind of a catch-22. Without a clubhouse, it's pretty hard to get year-round equity members. Okay, but if you don't have year-round equity members, how can you afford the clubhouse? Okay, so, and the fact that even if we extended the existing agreement, okay, paying them out in drips and drabs over that long period really didn't help their financial condition that much. Okay, so if we give them a payment, it's up to them. They'll have money to build a clubhouse. If they try to just flip the land and go, we're going to get it really cheap, and then we'll have all of it. Okay, but in the meantime, we're totally separate. That's, I think, a concern that a lot of people have raised. I know they've raised it to me. Is aren't we kind of doing a backdoor thing to build them a clubhouse and stuff like that? No. Once we make that payment, we have no other ongoing financial obligations. They run the business the way they want to run the business, and we own the land. We're protected perpetually. Okay? So what happens at the golf course? We're going to lease it back to them. Okay? We do not want to get into the business of running the 18-hole golf course. We've got our own golf course. That's enough. Okay? So what are the terms for doing this? Well, they're really pretty favorable for the golfers. Okay? We're just leasing it back for $1,000 a year plus a $1,200 a year reserve contribution. So they're going to pay us $2,200 a year. Okay? What do we get from it now? Nothing. Okay. Plus we have all the risks. Are we really trying to make this into a profit center? No. What we want is we want them to operate a country club if they can, and we're hoping they're going to be successful at it. Okay? Because that's going to help all of us. The only use that's allowed is basically a private country club, member-owned country club. It cannot become a public course or anything like that. Okay? Lease term, initially 50 years, 2 20-year options. We're giving them basically a perpetual lease. Okay? But they cannot transfer or assign the lease to anybody else. So this really is a, hey guys, here's your chance. Make your business go. And this kind of ties back to that 5-year, 50% right of first refusal in the sense that, I don't think anybody knows what the future of golf is in terms of, especially Northern Nevada, how many country clubs can Northern Nevada population support and all that kind of stuff. But my guess is in another 5 years, it's going to be pretty clear whether they can be successful as an ongoing club or not. And so in that sense, we're covered both ways. Okay? So basically, we're going to lease it back to them. We're going to lease it back to them cheap. Hopefully they'll be successful. But the only thing they can do with it is run a private member-based country club, and that's pretty much it. Okay? There's some more parts of this. Right now, they operate the water facilities. We're going to let them continue to operate the water facility. They operate them for us, is what I mean. They obviously water their own course, but they operate everything that waters Canyon 9 and so forth. We're going to let them continue to operate them. We will own them, but they're going to operate them and provide them as a service to us. We're not, I'll come back to you. There's some technicalities in what's known as the water sharing agreement, which is already in place. But basically, we're not going to pay extra for them to operate it. Okay? They've also agreed that we have the right to basically all the information we want about the status of that system and how it's operating, and they have agreed that they will train designated SOA staff people on all aspects of running it. So if the time comes when we do need to run it, we can just step right in. But in the meantime, we don't have to hire any more people or go through a lot of hoops to provide the water for them, because they already operate it, they already maintain. We've got a water intake and a pump house down at the Truckee River that takes a certain amount of operating stuff every year. We've got the one that's out here on the walking trail at the pump house. There's lots of pipes and sprinklers and stuff, but they'll basically operate the system the way they do now, but we'll be prepared to step in if we need to. We also negotiated a number of protections in case they don't operate either the golf course or the water system to the standard that we want them to both protect Canyon 9, but also, even though they're going to be operating a golf business, we want that to be a premier golf course. We don't want it to look like, a municipal golf course with big brown stretches and stuff like that. So the protection's there. Okay, the agreement will have, the final agreement will have maintenance standards, as we have maintenance standards now for Canyon 9. Okay, we will have the right, if they don't operate as a golf course or maintain it to our standards, we've got the right to come in after 45 days and take it over. Okay, the 45 days, which right now under the revert agreement it's a year. Okay, 45 days was actually their idea, which I thought was kind of interesting. But what it really does, it reflects how quickly a golf course can go bad because of all the specialized care you need to go. Now, obviously, if the 45-day period is in the middle of winter, it doesn't have that impact. But if this is during the growing season and you leave the golf course by itself, in as little, they believe, they assured us, in as little as 45 days, you've got a lot of problems. in terms of what it's going to cost you to bring that golf course back. We actually started out talking about a much bigger number, and I don't know if he was joking, but one of the guys said 45 days. We said done. So that's part of it. Even though we're accumulating reserves, and obviously we're going to have to get our reserve consultant involved in terms of exactly what we take, they are responsible for all maintenance and operating expenses inside the boundaries of what we're leasing back to them. Okay? So if their cart path, they have freezing, buckling, that kind of stuff, they've got to fix it. If they need to fix one of the bridges over a waterway, that's theirs, it's not ours. Okay? We're not taking on any maintenance responsibility within the golf course or within any of the areas, the driving range, the maintenance building, the stuff we're leasing back to. We're not taking on any maintenance responsibility for that. Okay? If, however, and this is true of the water system too, however, if they fail to make repairs, we don't want it such that they can just ignore stuff and let it go from bad to worse. Because a lot of times, as everybody I know has experienced, that sometimes you have a problem. If you fix it right away, it doesn't cost very much. If you let it go, it costs quite a bit to fix it later. If they don't keep up with, appropriate repairs, we can make the repairs and bill it back to them. So we've got the right to enter the property, make the repairs, bill it back to them. Okay? And they will be responsible for, obviously, all the costs of running their business. Whether that's the insurance for the golf course, or whether that's business permits, or restaurant permits, or whatever it is. There's one issue which is unresolved, and it won't be resolved until we try to close this deal, and that is, if the SOA buys this property, do we have to pay property tax on it? For the most part, we don't pay property tax. We're a tax-exempt type entity. So on our common area, we don't pay property tax right now. Okay? But I've talked to our attorneys, and apparently this is the kind of thing that's kind of a judgment call by the assessor. So while we can make the case that it should be tax-free, it kind of depends on how the assessor wants to view it at that point in time. So what we've said is we'll make our best effort to categorize this as common area or however we need to make it non-taxable. However, if property tax is due, if the assessor says no, this isn't non-taxable, every year the annual property tax gets added to the lease cost.
What is property tax?
I don't really know.
Is the golf course paying property tax?
Yeah, you'd have to ask them. I don't know I believe they do, but they're also a nonprofit organization, so I'm not sure what the rates are and stuff like that. But the point is, what we did is we kind of structured it so anything they're paying for right now, they keep paying for. If they, whatever they're paying for in running their golf business, they keep paying for. This issue is pulled out separately because we will be the owners of that property. So, and we can't tell the state, look, no, charge them for the property tax. So we just agreed. If we have to pay property tax at whatever our rate is for property tax, we just tack it on and they pay. So again, the principle there is what they pay for now, they keep paying for. It's just that we're going to be, in essence, kind of the landlords, if you will. Next question that I'm sure a lot of people are asking is, gee, why didn't we ask for more money for the lease? Well, in all honesty, we tried. We talked about all kinds of different deals and different ways to do this. But recognize this is an arm's length negotiation. We can't force our terms. We talked about higher lease costs, but then the price of the deal went up too. Just like they tried us to take over certain things, and we said, great, we'd be happy to do that, but the price of this deal is going to drop quite a bit. So, basically this was a negotiated deal, and that's where all the numbers are. And it's really important to understand that when you go through the letter of intent and you start thinking about this stuff, you can't really do, oh, I really like that term, but I would have done this one differently. Because believe me, we looked at all that kind of stuff. And this is a deal that both we had to agree to and they had to agree to. To us, getting control of the land and the water and getting the reverter rights at such a low price was worth more than charging them a couple thousand or whatever more, 10,000, whatever number you want to pick. It was worth more than doing that. Plus, you know, if you get to the point where it's a business to lease out the golf course, then I'm sure it's not going to be tax exempt. Okay, because that's a money-making enterprise, which is a whole different issue. One of the reasons why we wanted to do this lease back, okay, and we looked at this from the point of view of, what about just buying the whole thing and making it a community golf course? I know other people have thought of that, okay? Our basic calculations on this was we could do that, but starting right now with the current number of units, we would probably have to add somewhere between $50 and $70 to everybody's monthly assessment. Okay, and that's on top of the $15 that's already baked in. So our judgment was we probably wouldn't have a lot of support in the community to come in and say, hey, we're going to raise your assessment by $70 a month. Okay? And I'm sure people can say, oh, well, it doesn't have to be that high because, you know, we're obviously going to have greens fees and, not obviously, but obviously the option is there. You know, we'll have greens fees, people play for their golf, but now you got to get into, okay, how many rounds really are going to get played? Okay, and if your projection's wrong, the SOA still has to cover the deficit. Okay, and by the way, the 50 is making an assumption that there's a certain amount of revenue, you know, generated. Can that go to 40? I don't know. You tell me how many rounds played. 70 is pretty close to, if you took the operating expenses of the golf club, shut down the restaurant, and basically just operated the course. If the Somerset Association pays for that in total, it was like $69 and change to the monthly assessment. So yes, if a lot of people play golf, and depending on how we set the greens fee and stuff, it could be less than that. But if our projections are wrong, we're probably talking about a special assessment because the bills still have to be paid. And if it wasn't budgeted, you know, for more money, where's that money going to come from? You know, you guys know enough about how associations work. That could be a special assessment. So, for all these reasons, and for the fact that if they operate the course and they're successful, then it's going to be, you know, a high-class, top-notch country club which will support everybody's property value. So, let's give them a shot at it, because I don't think our members, by and large, would vote for a $50 or $60 or $70 increase in their assessments. I mean, how many people here would vote for $70 added to your assessment starting January? Okay, well, one person. No, but that's okay, because I think that's representative.
She doesn't even live here.
Okay, but anyway, so that's the thing with that, okay? The other question, though, is what happens if the golf course fails? What are we stuck with that? Well, the good news is we already own all the property, so it all reverts to us automatically. And this is really important. If the golf club went into bankruptcy, for example, it doesn't matter what contracts we have with them. Bankruptcy judges have almost unlimited freedom to just say, no, we don't like that contract, it's void. Okay? So, and I know people have brought up before, under the current contract, which a lot of people don't like and would like to see go away, that's what gives us, if you've heard about, we can buy the golf course for $1 before they go bankrupt. Okay? But there's nothing that stops a bankruptcy judge from saying, oh, well, you sold it to them for $1 30 days ago? No, it's coming back in. What's the most we can sell? The job of the bankruptcy judge is to get as much money as possible for whoever the creditors are. So if that means selling that to a developer to build houses or potentially even commercial stuff, whatever, the bankruptcy judge has that authority. or potentially has that authority. It also, there's a problem if you think about it. Let's say the golf course guys disappear, whether it's bankruptcy or they decide it's not a good model, or let's say they sold it to Golf America, and Golf America decides to shut it down. Okay, we do not have access to get water to Canyon 9. We cannot go in there and turn on the pumps. That's trespassing, presumably breaking and entering, because we have to get in to get to where the pumps are inside a building. We do not have the legal right to do that. Okay? So what do? We go to court, we get an injunction, we get permission. Even if you try to fast track that, the chances of getting that overnight are basically nothing. It takes time. What happens at the golf course, as we said, golf courses go bad very quickly. We avoid all that, okay, because we already own it. So anything happens and the golf course goes away, the golf club goes away, we're already covered. So what happens then? Do you have to pay $70 a month extra? It's going to be up to you. It's going to be up to you with whoever the future board is at the time that happens, okay? But basically, if that was to happen tomorrow, I'll tell you what the current board thinks, we'd put it to a homeowner vote. We'd say, look, you have two options. We can either keep it as a golf course for the community, and it's going to cost you $70 or whatever it is, or people can vote and say, we like Canyon 9, we'll just stick with that. We don't want a big golf course, let's make it green space. Okay? We've got the water, we can keep it green, we can use it as amenities. We have, we can actually put additional amenities out there. It protects the property values either way. And the choice will be up to the homeowner. Or at least I should say, assuming the CCNR changes passed, because it's clearly more than $500,000, well, choice is up to you. Okay? But anyway, that's what we see happening if the golf course fails. Okay? So bottom line on all this stuff is we think we've got a situation here where the Somerset Owners Association and the property values are protected either way. And I think that's really important. Okay. Now, I know this is getting long. We're getting toward the end. We can do the next slide. There's a bunch of other stuff in the letter of intent. These are the other topics that are covered. Okay. It will be posted. Like I said, everything will be online by Monday afternoon. Please read it. See what you think about the rest of it. If you don't understand stuff's in there, please ask questions about it. Okay? But there's a lot of other points, and then as we go forward to draft the new agreement, there'll be even more details. But, okay, what are the risks to the SOA from doing this deal? Well, one is the availability of financing. But so far, we've talked to, well, I should say Ray Lee has talked to several banks to get general information about would they be willing to loan money and under what terms, stuff like that. So far, not a problem for anything. Okay, we think that right now 5% is about right. They're willing to loan money. I know the Finance Committee, I believe, is looking at possibilities for refinancing because we do have mortgages on this building on Canyon 9. Maybe the two things can be rolled together, or we can get an even better deal. I don't know. We'll certainly be talking about that with the Finance Committee. But this does not seem to be an issue right now. Okay? Problems, there could be problems that we don't find when we do inspections and stuff like that. But the 4-year warranty, I think, mitigates a lot of that. Okay? This deal, these are the points, everything I've talked about are the points that all the parties have agreed to, but it's not a done deal until we draft the final contracts and get everybody to sign. Okay, which is also why we can't have a vote sooner on this, because what you're going to vote on is the actual contract, not a letter of intent. Okay, so the actual contract will get done, it will get signed, it will be made available to everybody, and that's when we'll start voting. Okay, the other thing, obviously, the homeowners, all you guys have to approve this deal from our side, but the equity members of the golf course also have to approve the deal from their side. And believe me, their negotiating team feels exactly like we do right now. There's good stuff in here that they think everybody will like, and there's stuff in there that they think they've got an uphill battle. Okay? And that's what we're all going to be going through as an education in the next few months while we're trying to do the contracts and the due diligence. We're going to have more of these kinds of discussions because I think the best outcome is if everybody understands this deal.
How many equity members are there?
Let me come back to that. I will answer that question. Next steps. Okay? I'd like to get the momentum of this thing going because we're talking about this instead of going off on a sidetrack. We're going to have a lot of these meetings. Right now, there are 3 scheduled already. We expect to have between 6 and 8. Okay? Because, as I said, everything's going to be posted on mySomerset.com. We're going to be, let me go back to this point. This is not an easy deal to understand. So as you read this and as more information comes out, I'm sure people, everybody's going to leave here today with 2 or 3 things stuck in their mind. And then if they think about it more, they're going to go, I didn't understand that other part or whatever. What we really want is everybody to let this sink in, ask questions, talk about how to do that. Come to another information session if you can, or as many as you want. Make sure you understand this deal, as opposed to focusing on 1 provision or 2 provisions, something like that. In the meantime, we're going to be starting our due diligence. In parallel, we're going to be drafting the detailed agreement. Once these are done and signed, they'll be made available to everybody. Okay? And we're not going to start the vote until all that's done. These are our expected timelines. Probably take, especially with the holidays, maybe 90 days or so to do the due diligence and the contracts. Okay? We'll make these available as soon as they're signed. What we would expect, assuming things go in the way we expect, that would say probably around beginning of April we'll start the homeowner vote, and we'll probably let that run about 90 days to make sure everybody can really think about this. You're not going to be under pressure to make a decision. We'll have a lot more homeowner information system sessions. I think we really want everybody to understand this. So what's the bottom line?
Does it take a simple majority?
I will answer all the questions when we get to the questions and answers, okay? We think that this is really a win-win for both sides. Somerset gets protected whether the golf club is successful or not, okay? If they're successful, we're going to have a really good private club here. It's going to raise property values. People can join that. Values go up. If it fails, we still have green space at the worst. Okay, or we have a community golf course, depending on what the homeowners want. Okay, the golf club gets their best chance to grow and succeed. This is what they've kind of figured out from all their efforts, that they really need to kind of take a quantum step. This is going to give them that opportunity, but it's up to them whether they succeed or not. We are not responsible for that. We do not have any ongoing obligations to support that in any way. Okay? We really believe this is a unique time and a unique opportunity. I doubt that, especially with regard to getting the reverter and the water rights, I doubt that we could negotiate the same deal. Even from the golf course guys, I doubt we'd get the same deal 2 years from now, 3 years from now, whatever. So it kind of, in our mind, is a one-shot thing to say everybody's going to have to decide. If they think this is a good deal and we vote for it, we get the benefits that we're talking about. If they don't think it's a good deal, they vote against it, that's fine. Everybody's free to vote how they want. But please think about the long-term impact and whether you really think a better deal is to be had. So where does that leave us? Well, the rest is up to you guys. Okay? That's what I said. It's a careful deal. It really needs some consideration. We urge you to attend more than one information session and ask questions. We are going to be setting up on the My Somerset website a separate page you can go to which will have all the information related to this deal and as it develops. We are going to try to do something that hasn't been done, at least here before, is we're going to try to do a frequently asked questions type page that'll be here with all the rest of the documents. So if you have questions, whether you're reading this stuff or you reflect on something in a meeting and say, gee, I didn't understand how that fits with that, send an email, call the front desk, leave a message for any of the Melissa, Lauren, Sean, any of those people. We will periodically gather those up, look to see how many similar questions, how many different questions. We'll post answers. Okay? But the most important thing is decide for yourself, and when the time comes, please vote one way or the other. That's the only way we're going to know what people really want. And we certainly believe the best solution is going to be reached if everybody takes the time to understand this, think through what's important to them, think through how it affects the whole community, and then vote however you will. So that's basically the deal. Okay? So with that, do you want to say anything before we start questions?
Yeah, before we start questions, as you can see, this has been a long time coming. This has not been without major negotiations on both sides, without thought. This is not, what we hope you walk away with is that this is a win-win for our community. And this is not, we don't want to be in the country club industry. The country club guys do a great job at keeping that golf course green, and that's what we want them to continue doing. We want them to succeed as a country club. We do not want to be in that business. As the homeowners association, our main goal here is protecting our community, protecting our home values, and making sure that Somerset is maintained as a premier community here in Northern Nevada. And I hope that that's what you guys are walking away from. The big points of this deal, should it pass, are the water rights. Tony did hit up on this. If you were to call Tumwa today to buy 1 acre foot of water right is about $6,000. We are walking away with water rights. We are walking away with, and again, we'll be in a partnership with the country club as a silent land owner. We want control of the pumping stations, the water, and keeping that space green in the long run. Again, we don't want to be in the country club industry. We want to protect our community, and the major vein of our community, that you see in red is the golf course. So, and also the reverter rights. If we don't get this passed, we don't get those reverter rights. And that is something that is really, really pivotal to this negotiation and this contract, is that Blake can say, well, if you guys don't work out something, I'm not giving you reverter rights. So again, if you walk away with nothing else today, we hope you understand the importance of the water rights, control of that green space, and the reverter clause. So, I don't know.
Okay, so, no, we'll just go ahead and we'll do questions and answers. We'll stay here as long as people want.
By the way, it's great
Thank you
to
all.
see so many faces.
Are any of the land or real property will be acquiring in this transaction under lender payments right now? And if so, who's paying that mortgage?
Okay. The question was, if everybody heard, is basically, are there any mortgages or loans on the land we're acquiring? As far as we know so far, no. The answer is no. That is obviously something we will confirm during due diligence, because if there are any liens or attachments or mortgages or whatever, that obviously changes the way we look at this. But we have asked that question. We know that the golf course was turned over to the equity members with no debt on it. But we will check that to be sure, but we have negotiated this and we have asked that question on the basis that there are no loans on that. In fact, if you saw one of the earlier versions, that was, especially the maintenance building. That's $1.5 million building that got put up And that would be an obvious one to have mortgage if there's going to be a mortgage. So the original versions of this was if there's a mortgage on that, they have to pay it off before we buy it. Okay, we were assured there isn't. We will confirm that in due diligence.
You talked about water rights. In your comment, you talked about the 9-hole golf course. But I also thought I heard you say something about common areas. If water gets turned off, does it impact the common areas?
Well, the answer is no, it doesn't. The golf course is a common area. So maybe that's what
I'm talking about, all the way.
right, you're talking about the landscaping. Yeah, we've actually looked into that to some extent. The question is, if the water gets turned off, if we don't have access to the infrastructure, does that affect a common area other than the golf course, our landscaping and stuff? Is that, okay. The answer to that question is no. Again, all these things will be confirmed in due diligence, but here's what we understand right now. The way the water system was designed, the water system for both golf courses, Canyon 9 and the 18-hole, are independent of the water system that waters landscaping in our common area. One of the questions we did pursue was whether or not, and this affects, do we give water back to the golf course, because what if we could use that water to water common area? Well, first of all, right now, the way the system's designed, we can't. So we have to build, some interconnections and stuff. But more importantly, TUMLO will not let us attach water that doesn't come through them from our wells or from the river to any system that carries water that has been processed by them, to any potable water. Okay? So they will not let us do that. So we don't really have the option of even saying if we were willing to spend however much it costs to interconnect the pipes and use any extra water to save on our water bill. If we separate our water, landscaping water system to do that, we cannot go back if there's not enough water to TUMLO and say we want to buy more water. They will not let us interconnect the systems. That's my understanding.
So water in the golf course is raw water straight from the trucking.
Yeah. Yeah. And also, we have runoff from the mountains that goes into ponds, so does the golf course. Yeah, it's basically untreated water that's drawn out of various ponds. For us, it comes out of the pond behind this building. For them, I think it comes out of the pond on hole 14, wherever that is, because I don't even know what hole 14 is. But yeah, that's our understanding. And also, the way it's designed, the water only travels in certain directions, the way the system's designed. So right now, the only use of the water for any of those permits is to water one golf course or the other. Okay.
How many equity members are there?
I believe the number right now is 116, 119.
117. 117.
117.
How many were there in 2008?
I don't know. I wasn't around. Well, I guess I just moved here then. Now, as I understand, their maximum number is 450 or something around that. Their target number is about 400. If anybody knows better than
That's
that,
correct.
please.
450 is correct.
450? Okay, that's the maximum target based on not having people backed up on the golf course and stuff like that. Well,
These are country club
Yeah.
operating questions.
Yeah.
I'm sure at one of these information sessions that we will have in the future, we'll invite the country club as well, and they can better answer their business model and their projections than we
Yeah.
can.
But the key thing in the agreement is country club the area would be protected.
That's right. So we're protected either way.
We don't care what they do with the $2.75 million. That is their business model. That is up to them. What we care about is protecting the integrity of the community. And that's what we hope we are accomplishing with this.
Yeah, in that regard, if the country club does fail and we get the land, I didn't see anything. Have we estimated what it would cost us to maintain it as a green belt, and would that affect assessments?
Well, I don't know. We haven't gotten it because obviously it depends on what kind of green belt you maintain it as. whether we just keep it as grass, whether we want to plant it, whether we want to build tennis courts somewhere on it. You know, it obviously is going to depend on all that, but it would be, to maintain it strictly as greenbelt would be obviously a lot less than maintaining it as a golf course, and we know that maximum number is $70. So, but, you know, that's something that we have to deal with at the time.
Yeah, other than the loan payment for the 2.75 million, what are the expenses associated with purchasing, you know, the land and water right? And will we be able to see like SGCC's financials? And that would show us what percent that they're relying on our association to keep the green belt, you know, keep the grass green.
Okay.
And also, well, the 2.7 million, how much relief would give to them to operate their current operation?
We would not give them anything. I mean, that's it. It's a one-time payment, and it's done.
We're paying 2.75 million.
Yeah.
And how much relief would that give to them for their current operation? Obviously, they can't maintain the current operation, like based on the current membership.
Well, that's the reason we negotiated the deal we have. As Danielle said, that we are not really concerned with running their business. We negotiated this as an arm's length deal. Believe me, they wanted a lot more than 2.75. But whether that's enough to make them successful or not, I have no idea. Okay?
I guess our concern would be how much responsibility are we also purchasing with that 2.75 million?
Responsibility for what?
For as maintenance, I mean, we're owning the land and waterway. And after the 4 years, well, even during the 4 years, is there any additional responsibilities? Or after the 4 years, what's the estimate of cost of maintaining, you know, what we own? And,
Well, again, as long as, you know, there's two scenarios. As long as the golf course is there, I mean, the golf club is there and leases the land, our responsibility is basically zero. Okay? When you read the letter of intent, you'll see some weird stuff about the only place it comes in is with certain water facilities because, for example, they've got, if I remember correctly, they have 6 wells permanent. There are only 2 wells that are actually drilled at this point. But they have 6 wells permanent, and those wells, one of them is located inside the property lines of what they're leasing back, one of them is not. Okay, so then you get the question, well, okay, do we have responsibility if something happens to the well after the first 4 years? Because the first 4 years we don't have any responsibility. That's set up basically on a proportional basis. If a break happens somewhere outside the boundary, it depends on, you know, they get a proportion and we get a proportion based on where, you know, how much of the pipe is inside or outside the boundary. Read the letter. We got to flesh this out more. But if the golf course succeeds, we basically don't, you know, we have very minimal responsibility. If the golf course fails, it's the same question Jim asked, and then everybody's going to decide whether they want it as green space. You know, the only thing I can really respond to that, and we'll look into that more, you know, as we start doing the due diligence. But to me, the real question is, what's the downside to Somerset as a community from losing control of that land versus what's it cost to maintain the grass? You know, which would basically be, obviously we wouldn't maintain it if the homeowners didn't want it, we wouldn't maintain it as a golf course. So now we're talking about basically lawn area like we have in other common areas. And I would expect that cost to be fairly minimal. I don't know what the number is, but the real trade-off is, you know, whatever number you think it might be, is that more or less important than ending up owning that land and controlling what could happen to it?
That's a good point.
Yeah.
I guess right now we're willing to see some figures as
Well,
far as cost benefit analysis, how much is that associated to us to keep that area open?
Well, like I said, we'll look into some of that. We'll come up with some, ideas based on what it costs for a common area. The other question you mentioned was, are there other costs associated with completing the deal? Yes, there are some. We're going to do some inspections and stuff. Obviously, we're going to have to hire an inspector who knows something about.
So would that information be all available by the time of voting?
Oh yeah, well, that kind of stuff, yes. Well, some of that.
Like potential property tax and potential cost associated with the transaction,
Right.
and potential future cost during the 4 years and after 4 years.
Right.
And down to, per family.
Well, we're assuming there's going to be some transfer tax, okay? That's covered in the letter of intent. Take a look at that. We're going to have inspection costs, due diligence costs, stuff like that. Those costs should be pretty small compared to the 2.75 million. At least that's what we would expect right now. But again, the real question is, if I said to you, we're going to spend, $32,000 to do inspections. There's obviously going to be costs related to drafting contracts. Okay, but these are costs we bear every day for all the rest of our business anyway. Okay, that's what we have to do. If it costs $30,000, $40,000, well, maybe to some people that's enough to say we'd rather let go of the land and take our chances that it will not be developed. Everybody's going to have to make that decision. We are not trying to hide anything here. We will make information available. People that ask questions, we're going to keep fleshing this out. We've got, according to our time frame, it's probably going to be maybe 5 months before we even start the vote, which means there's a lot of time in here to really flesh out some questions and post some responses.
Yeah, I want to kind of expand on that, what was said. I understand what you're saying. Some of this stuff is qualitative. How you feel about having something that looks like Northgate in the middle of your community versus those who care about that.
Right.
Some care, some don't. But some of it's quantitative.
Right.
I think that's what's being asked here is.
No,
So on the website, we're going to be able to see a spreadsheet showing what the costs are by the time we vote.
Well, I don't know whether it'll be in the form of a spreadsheet, but yeah, we'll have. It might be in the form of a number that says, here's what it's going to cost. We did estimates or we got bids and it's going to cost, $132,000 to cut all the grass in the golf course.
This is why we have,
Transfer versus.
Right, we're going to, things like, for example, property tax, we're not going to know how that's handled until after this deal closes when we go to the assessor to transfer. But,
I'm talking about.
yeah, I know, I'm saying, I'm just pointing out some of those things we will not have. Property tax, we don't know how that's going to be treated until we go there. However, we've got the provision in there that says if we have to pay property tax, we add it to the lease. So the association is not going to have to pay property tax.
we're not gonna have all the answers to your questions right now. This is why we have a due diligence period. This is why we have a due diligence period, so we can gather as much information as possible to be able to better inform you prior to voting on this. This is why we're not sending out a voting ballot right now. We have to finalize the contract with all the numbers, make it available to the homeowners, and then put it to a vote.
The question I asked was, will we have that information before the vote? Which is
You will
the question
have
being
as
asked.
As much information
as
as
we can
we
get.
have
Yeah,
in our due diligence
Yeah.
period, we will then make available to you guys.
And it will be a complete picture.
Well,
There's
we
gonna
can't
be-
promise, because I have no idea what you mean by complete picture. Okay? Well, that's why we're asking you to ask questions as this develops, so we can find out what you think.
And the other thing
They
too
want to
is,
see the SGCC's financials.
that's up to them.
That's up to them. That's their business.
That would give us some picture of
Well,
what is the cost of their operation, how much are relying on this association.
You guys-
And future expenses.
the deal where they rely on us goes away, okay? If this is approved, that deal goes away, okay? Whether they, can you tell me, even if you saw their financials today, what does that tell you about how, well, hold on, about how they're going to operate 5 years from now after they have the 2.75 million lump sum? It tells you really nothing about that. And quite frankly, from our point of view, We're gonna get the land one way or the other, so.
Because you, a possible intent of where that 3.75 million would go, and it tells you.
That's
That doesn't tell you that at all.
Business model, that's
Give you
not,
some idea of the future expense of what.
No, because what their financials show is where they are right now and how they've gotten there. It doesn't say anything about the future.
Their balance sheet and income statement, that would show a lot.
well, this thing has been very.
That education.
Well, you had a question
I
for,
had my
yeah.
hand up.
Yes, you have.
I have two things. To answer her question, their financials should show it's nothing. Their financials are based on running the golf course. I highly suspect that keeping a green belt, which is not going to be mowed and cared for as a golf course, is to be much, much less. Those numbers would be useless to us. If we get someone money for purchase of property, whether it's our own home or the golf course, we have no say what happens to that money. So that's also null and void. The one question I did have on the contract that will be signed and then presented for vote, is there a clause in the contract that states subject to approval of vote of the association?
Yes, there will be. Yeah, that is in the letter of intent, and it will be in the contract. No, there is no way this is not going to go to a homeowner vote if we get the agreement signed. There's just no way that's not going to happen.
Well, I realize that,
Yeah.
but the contract is not finalized and not official
Right.
without.
No, that clause will definitely be in there. It will be subject to approval by homeowners. Well, what percentage of vote needs to approve it? Okay? What we expect right now, and we will get a legal opinion of this when we get closer, but my understanding is, based on some stuff that Jim said as well, because he's been in touch with the Attorney General's office, if they're not going to come in and impose any other type of standard, I would assume this is going to be treated as a homeowner vote, which means it would be the majority of, 50% plus one of all votes cast, as long as we're past a quorum. And I cannot imagine this deal is not going to get quite a few votes past a quorum. This is going to be key to everybody.
What will the quorum be?
Quorum, well, for a homeowner vote, a quorum is 20% of homeowners, okay? And I know there was a lot made recently about, oh, that's way too low. That's the state law, okay? But let me give you some statistics to put that into context in terms of what it really does, in terms of making it easier or harder for homeowners to do anything, okay? Homeowners have rights independent of the board to call meetings and to transact business. The quorum for that is 20%. We've just adopted Nevada state law on that. That's the quorum. That makes it a legitimate vote. The actual vote is decided by 50% plus one of the total number of votes cast. So like in our election we had recently, I'm not sure what the number is. I think, Lauren, do you know how many total votes were cast?
999.
999. So, if that's what's cast, then you need 50% of that plus one vote. Okay? Give you a little perspective on that. The Moana vote. Okay, we had that vote last year about continuing the litigation, which we just settled earlier this year. We got $375,000 for that. Okay? In that vote,
It's going to go in maybe
okay. Yeah,
5 minutes.
our battery on the video is going to go soon, so when it does, I'll stay here and answer questions, whatever you want, but it won't be on the video. 95% of all votes cast were in favor. Okay? But that, because there's a special provision in Nevada law, that required a 50% plus one vote of all eligible voters. Okay? 95% were in favor. You know by how many votes we cleared that hurdle of 50% plus one? 33 votes out of over 1,300 cast. Okay, so when you really think about this 20% homeowner form, What it really does, if you raise that number, it basically eliminates the homeowner's ability to act independent of the board. Because, if you've got an issue that's more closely contested than Moana, so that, you get 60-40 in favor, or 70-30, or something like that, you're going to need to get like 2,000 or more votes cast just to be able to reach that 50% plus one. Even with something that was as clear-cut as the Moana vote, 46% of the residents in Somerset, or the owners, however you want to look at it, did not vote. Which means if you need a 50% plus one standard, 46% don't vote, 5% of the homeowners can defeat anything. So think about that one for a while, because that's the way the numbers work out. Okay? So what we expect right now, subject to any changes in legislation, because our rules change automatically with whatever the legislature does. We don't have a legislature coming in session, so hopefully nothing happens. I would expect that this is treated as a homeowner vote, not a board vote. That takes different numbers, but as a homeowner vote. So that's what I would expect.
So after all this summary, it's 300 votes you have to have as a minimum, approximately. Did I read that correctly? 20%, 1,500.
If only 496 people.
Yeah, if exactly 496 people vote, then you have the 200 and whatever it is that can make a decision. If 497 people vote, that number gets one higher. If 1,000 people vote, you need 501. If 2,000 vote.
So what, after all that explanation, you have to have 470 minimum?
That's a quorum.
That's a quorum. And if you don't get that, then this doesn't go.
Correct. Right. And, well, there's actually some other legal complications. Basically, that's right.
Yeah, I would,
Wait a minute, hold on, wait. Ed has not asked a question yet. Let me
If the CCR changes do not pass,
Right.
can this deal go forward?
Yes. The way that would work is, in essence, a vote to approve this deal is also a vote to let us implement the deal on a one-time basis. So if the CCNR changes do not pass, well, actually, whether they pass or not, will still be a homeowner vote. Because even if they do pass, it's above the level, which right now our rules do not have any financial maximum that requires a homeowner vote. So, but what would happen is, in essence, there'd be the homeowners would say, if the vote passes, they're saying, we want this deal to happen and we're authorizing the board to do just this deal. So there would not be any permanent changes to the CCNRs, but this deal could still be done. That's what we anticipate the way it would work. Okay, Jim.
yeah, I would like to say that I agree that if you had to have 51% of all eligible homeowners, I think that's an unreasonable standard for this type of a thing. Jim R agrees with that, okay?
I hope to see that posted on a prominent page.
For a couple of reasons. One, to try to get that many homeowners to vote is like, pulling teeth. We know that. And that probably wouldn't be accomplished by the mid-June date you have before the Attorney General's office goes ahead with the complaint, because you only got a 10-month period to do it. But I would disagree a little bit about it has to therefore be a 20% quorum. That's the minimum that's established in the NRS requirements. It's like a default quorum. It can always be superseded by anything the board can do in their own governing documents. So you could establish a 50, a 30, or a 20.
Yeah, no, technically we could. However, establishing that would require a change to the CCNRs, which does require a 50% plus one of all eligible homeowners. So, I mean, yeah, we could, but our current CCNRs say we follow state law. So if we wanted to change it to 30, 35, 40, 50, 80, whatever, we have to change the CCNRs. And so that has its own hurdle associated with it. But you're right, that could change.
I want to thank you for a very clear presentation.
No, thank you. I saw him.
I want to react. You just said, thank you to you, Tony, to you,
volunteer their time to make Somerset a better place for us to live. And I am very pleased with what I see here, and I just hope everybody realizes the importance of those water rights. You know, it is so, so crucial. But I say thank you. You are not our enemies. You are just looking out for our best interests as homeowners in Somerset. So
Thank you. I appreciate that. Let's go on.
Tony, looking at the numbers, I wonder if you look at them the same way I just did the math. $2.75 million divided by 2470, because 2478 are the number of members. That's roughly $1,100 per property owner. Is that not correct?
Well, I mean, that's, you know, we're talking about financing it. If you want to pay a lump sum, it's probably correct.
But before the financing. Okay, then there are 125 roughly equity members in the country club. We're going to be giving them $22,000 apiece as equity members of the country club. Is that not correct?
I
Roughly.
haven't done those numbers, but I'll trust your numbers.
Well, I just wondered if those numbers are accurate.
Yeah, I mean, I haven't run the numbers that way. I guess my question back to you is, what's the relevance of that?
Well, you know, a privately held company is being given $22,000 per equity member by the members of our community, and that's a significant amount of money. By the way, thank you for all the work you've done, and you made a great presentation.
Yeah.
I don't think there are many questions on the presentation. That it's very well done, and we understand, and I understand, my wife and I understand your points.
Okay. I mean, my point, though, just to respond to that a little bit, though, is we are buying